All rise, please. The score is now in session. Judge in front of you is number 13.
All right.
Everybody else, please be seated at this time. You may be seated.
Okay. This is on the motion for summary judgment.
Yes, Your Honor, we've actually reached an agreement for entry of judgment in exchange for 120 days. I just can't have it say that it's a consent.
And it will not. And it will not.
Thank you.
Thank you, Judge.
Handed the court the original.
So how did you wrangle,
Arm wrestling.
120 days?
Arm wrestling.
Well, they're in
Very
loss.
impressive.
They're in loss mitigation. So
Okay. July 1. Oh, you got the date in there already?
yes, Your Honor.
Just so that there's no
Come on
question.
now. Come on now, Judge. We know better than that. Right here. This is your copy. You're welcome.
July 3rd.
Yes, sir. July 1st. Thank you, Your Honor.
Yes, ma'am.
Number 9. Okay, have a great day, Lauren.
Good morning, Your Honor.
All right. Good morning. Give me 1 second.
Sure.
All right. This is on U.S. Bank Trust versus Lovett.
That's correct, Your Honor. It says our motion for final summary judgment, Cynthia Ramos and Tim Scalero.
From Robertson Anderson and Schneider, Your Honor. Just and for the court's notice, I was actually just a runner for the note and mortgage to counsel here. So I haven't reviewed anything, but I'm going to let her take the lead on it. I was just filling out a notice of filing on the originals.
Okay.
We had a title claim on the file, Your Honor. There was a defense raised of forgery of the note and mortgage, actually just the mortgage. And we served requests for admissions and asked for any evidence supporting the forgery. Nothing has been produced.
It's all in your
It's all in my motion.
motion, so.
I've brought 2 forms of judgment because it's within the court's discretion to accept the admissions. Or if you'd like, I have subrogation language in my form of final judgment so that in the event that the heirs of Michael Lovett want to protect their 1/2 interest, they can based on the subrogated amount. And I can show you the form of final judgment if you'd like to see it. So because there was
All right, well, put yourself in the shoes of them. What would you rather see?
For all intents and purposes, Your Honor, it's actually the same thing, because at the end of the day, in order to protect the other 1/2 interest, they have to pay the full judgment. My suggestion and my request to the court is enter the form of judgment with the subrogated amount, because it addresses their affirmative defense, and there's no claim at that point.
I think it does. I think you're absolutely right.
Thank
See
you.
and there's nobody here on the other side. They filed nothing
In opposition.
to the summary judgment motion, so.
That's correct, Your Honor. Thank you.
What are we looking at in terms of a requested sale date, please?
Any suggestions? Whatever the court wants to assign is fine, Your Honor.
It's a forward.
Huh?
It's a forward. Forward.
Yeah, no reverse. You don't
First
have
bill is fine.
to- yeah.
Should be fine.
All right. I'm going to make it 90 days in an abundance of caution. It's going to be May 28th.
All right, thank you, Your Honor.
And Your Honor, I'm drafting a notice of filing out of one of the short orders for the
Oh.
note and mortgage.
Okay,
So I'll have
good,
that
because
to
I'll
you.
need the original, yes.
I'll have this to you in a second. Thank you very much.
Thank you.
Number 4.
We pass that one, please.
Do you want to pass it?
Yes. Do you want to come up?
No, no. Have a seat for now. That's it, we don't have no other teams.
All right. Now, on 4 and 5, that's Sovereign's condo versus Hermance. There was going to be a court reporter who was going to be present. Do we know is the court reporter here yet? I guess not. All right, I'll keep passing it because the other
That was supposed to
parties
be
are also on court
an
call.
agreed order. I have an agreed order on number 4. But
Okay.
2 of the heirs have shown up, so I'm trying to figure out what's going on.
Okay, well, somebody also said that there's a court report. Well, no, I take it back. That's on number 1. And there are a couple people on court call
For number
on Sovereigns versus Hermance, which is that one, correct?
yeah, but I don't know why they're on court call. I have an agreed order between the plaintiff and 3 defense attorneys.
All right, Sophia Dean, Melissa Muriel. Do you recognize those names? I tell you what, let's call number 4. Why would we pass number 4?
Because one of the defendants is talking to her attorney outside, and the other defendant is
All right,
in
as soon as
here.
they're done.
And I'm trying to figure out what's going on since I do have an agreed order on this.
Okay.
What number you got?
I agree with you. Well, go out and talk to them, and then as soon as you get back, I'll take it up.
Thank you.
Okay.
Judge, let's go number 2.
I apologize for not having a notice of phone, but I had fashioned one and signed it with my bar number on.
That's okay. There's a note.
Thank you very much.
Hold on.
And I wasn't representing the buyer. Okay. Here's the approval letter.
Brenda Levitt.
No, they gave us
Brenda
an
Levitt?
extension.
No, we're not there yet.
That's the original. So here's the HUD statement. Here's our
No,
complaint
did you
to
sign
Fred
off
on
on
her,
them?
where she asked for 6%.
Who's here
then she
for
cut it down to
confirm copies on
3%.
Brenda Levitt?
There was the closing statement that showed.
Oh, yeah, the title counsel's back here.
There was someone else who checked in on this case.
The point is, I didn't want you to see, and I've got the funds in my account.
Was there somebody else that checked?
Yes, somebody else checked in on
I was making this, I was just talking, I got.
Oh, was it Glenn Miller?
So it's just like it's old and old.
Yeah, hold on just for a second. Let's double check to see that bag.
Thank you.
Just 2 and 3 judges,
Let me explain to the judge. I was caught up in the middle of this.
All right, which one you guys here on?
2 and 3.
2 and 3 is we both noticed it for hearing.
Okay.
Yeah, that's why it's 2 and 3. It was our motion to reset the sale, and there were 2 reasons. First of all, the court reset the sale on December 24th without a notice of hearing or an opportunity to be heard. The plaintiff submitted a motion to reset the sale date, and so our argument to the court is under due process, it was material. We wanted an opportunity to address the court to explain what's happened here, which dovetails into the second argument. Had we been here December 24th, well, I was on vacation for the holidays, but had we had an opportunity to address the court, here's what...
Don't brag, Mr. Cobb.
Not bragging. It was cheaper than getting another divorce. All right? How many can I afford? All right, so here's what occurred. We got a contract for a short sale in August. The bank approved the short sale in September with a closing date of October 15th. I represented the defendant, the seller. I did not represent the buyer. I have enough conflicts of interest in my practice. Closing statement was prepared by the attorney named Jed Friedman, totally unrelated to me. The closing statement showed a real estate commission of 6% coming from the seller, the bank's proceeds of the short sale, $24,000. I informed the bank that I could not be a part of this closing statement because the realtor was retained by my client at 3% or less. What the realtor did was she added a second realtor from her office, United Realty, and I showed counsel the closing statement. She added another lender, another realtor from her office, so they could increase their commission to 26. I told them that even though the money's coming from the banks, I'm trying to save the bank money, I can't be a part on a closing that might come back and be fraudulent. What occurred after that? We filed a complaint with FREC, the Florida Real Estate Commission. So it isn't just us saying that this was a problem. We actually filed a complaint with FREC that's pending. There's the copy of the FREC complaint saying that this is fraudulent and tongue-in-cheek, but I don't need more bar complaints is what I'm saying. I don't want to be part of a closing statement that I know is fraudulent. Now, if the bank wants to waive that, if the bank's attitude is, and we've been in touch with David White, he was the gentleman who approved the short sale from the Bayview, from Bayview. There you go. One second. No, this was the one we got back then from David. He was the asset manager at Bayview Loan Servicing. So even though it's Bank of New York Mellon, it's the servicing agent who's calling the shots. So what I'm saying is this. If the bank would simply state, thank you, Mr. Kaufman, for bringing this to our attention, but whether it's 3% or 6%, we just want our net amount. I'll close. But I don't think it should be incumbent upon me as an attorney with the canons of ethics controlling these situations that I be part of a fraudulent situation with the realtor. Now, I understand, and by the way, I do have all the money to close in my account. I brought a confirmation of the wire. So the point I'm making is this, Judge. I understand that the bank's attitude is it's been going on a long time. I'm not here just winging this. We did have a short sale approval. We were ready to close. This isn't my client's doing, and it's not the bank's doing. So what I'm asking for is a single final, no further resets after this, and that will give me a final opportunity. If need be, I'll travel to Bayview's office and see if they'll sign off on the 6% commission. It's their money, but I'm involved in the middle of this. And I don't think...
Then why not take the top 3%, take half of it, put it in your
Kim
trust
escrow,
account.
What's the
issue?
I just said that to counsel, that we would escrow that money, but since it's the bank who approved the total amount of the sale, I can't just unilaterally hold back their funds, so to speak. All right, I can't just say, listen, this is fraudulent, I'm going to hold an escrow. I exactly said that that's what I would do. I just told counsel outside I would hold the money in escrow. I just need Bayview Servicing to just give me a call or give me just a touch.
What's the position?
Our position is we're opposed to it. We want the sale to proceed as scheduled. This is a 2015 judgment on a 2011 case. This is not the first time this has been asked to be canceled for a short sale. There's about 7 resettings in this case. It's been up and down, twisted every way possible. There was an approval in August. Right. It was a half a year ago. It expired. In November, we sent them a letter. It expired. There is no approval. There is no review going on. I think we're entitled to the sale.
Okay, and the question is 3% versus 6%. You have no problem with the sale going forward, correct? You want it to go forward.
Foreclosure sale?
Well, no, with this.
I don't
With
care
the short
what
sale.
they do, but we don't have, my client, the owner of the judgment, has not approved it, it is not reviewing it, is not considering it, doesn't want to consider it.
Wait a minute. I thought the short sale got approved.
The short sale was approved in August.
Right.
It expired
Okay.
in November. We sent a letter, it's expired, it's done, we're not reviewing for
And
the
the
short
reason
sale
it
anymore.
expired is because.
I have a realtor trying to get 6%.
No. The
Yes.
reason it expired is because of what you just explained.
Absolutely, Judge.
All right, so you are the one who stopped the short sale from going through.
No, us?
Yes, you.
No. Well, not
You
us.
personally.
Me personally?
Yes.
Okay, if the court wants to view it as me personally, but ethically, how do I sign off on a closing statement? How am I, the attorney for the seller, signing off on a closing statement that's fraudulent, Judge? Come on. I understand I'm put in between a rock and a hard place. I'm not trying to hurt the bank. I worked diligently to get this short sale approved. We were ready to go. But I don't think the court should say that the bank approves a short sale. We've informed the bank that the Realtors Commission is fraudulent. Please tell us how you want to proceed.
How much was the final judgment for?
Oh, the final judgment was way in excess of the short sale contract of $415. I'm sure the final judgment, I don't remember offhand, but I'm sure it was in excess of a $415 contract price, netting the bank $354,696. Again, Judge,
When's the sale scheduled?
Monday the 4th. So we had to comply with your rules about 10 days, I think it was the 5 business
fine.
days.
I mean,
So,
we're ahead of it. We're,
So
just in
what I'm
case.
saying to the court is this: I understand it's taken a long time. I fully realize that. If the bank's position is, and if counsel can speak for the bank, I'm not trying to put counsel in a corner, but if the court enters an order stating that the real estate commission will be held in escrow by Michael Kaufman pending further resolution, I'll do it. Just something to cover my tuchus, Judge. It's not only fair, it's the right thing an attorney should be doing, and not just making unilateral decisions that have ethical consequences. So why can't...
Do me a favor. Let me
Sure.
pass it. I want you to talk to your client already, okay? I need to know the answer to whether or not, because if everything's there and it's still there now and the sale's gonna go through, what's the issue? And I would direct that the 3% be put into trust, because apparently there's a pending complaint. It doesn't matter. It still goes through. If you want to go after a deficiency, you go after a deficiency. If you don't, you don't. That's up to you all. I'm not going to get involved in that. But I understand his position, but I don't want to delay it. And there are two ways to not delay it. Either, number one, I let this sale go through, the short sale that you had already approved, or number two, I let the sale go through on Monday. I want to know from your client where your client's position is, up to date now. Knowing that the sale is going to go through when?
Monday
The short
morning,
sale.
the 4th. Oh, the short sale?
the short sale.
Oh, I can have that closed, I would
You
think.
better have it closed by Friday, because if not,
Today's Wednesday.
Yes.
I
everybody talk out in the hall. Come
Yes.
back and let me know.
yes, Judge.
All right?
Oh, I'll wait.
Judge, let's recall number 9.
Morning, Your Honor.
Morning.
Glenn Miller on behalf of the defendant.
All
I
right.
apologize, I was outside the hall.
Oh. While things are going on here in the
Yeah, I had
court, what are you
checked
going
in
to do?
before counsel.
No. They had checked and found out that you had checked in, and she had agreed to, as soon as she found that out, to stick around. So,
Thank you.
all right. So let me hear from you all. What's the situation?
Basically, we have agreed to a 120-day sale date. She said she has no objection. And the amount of her judgment is prior to another loan being signed by the decedent. So it's obviously not signed by him. And she said her judgment is prior to that. I have no objection to that. You wanna-
So, Your Honor, we have no objection to the 120 days that counsel is requesting, and
Right.
what I explained to counsel is that as to the 1/2 interest owned by the heirs of Michael Lovett, the amount is based on the subrogated amount paid for the prior mortgage. As to the other 1/2 interest, which there is no claim of forgery, it's the full judgment amount, and counsel understands that.
No, not a problem.
All right. So the bottom line is, the only thing that's going to be changed about this order is the date of the sale.
That's correct, Your Honor.
All right, which is going to be, now it's going to be July 1. And I'll do that.
Thank you, Your Honor.
Sorry.
Was that July or June, Your Honor?
No, July
July?
1.
Okay, thank you.
Okay.
Thank you.
Thank you all.
Number 1, please.
Hey, simmer down now.
Judge, you just don't know what I'm looking for.
I'm on this one, Your Honor.
All right, I'm sorry, what number is this?
Number one, Your Honor.
And we have a court order.
I'm ready, Your Honor.
All right, we're here. We're here on HSBC versus Justilian, case number 11-17796, 2011. Okay, all right, let me have appearances, please.
Good morning, Your Honor. Timothy Scalaro, Scolaro, on behalf of the plaintiff, HSBC Bank.
All right, morning.
And Joseph Paggi, Paggi, on behalf of defendants.
Okay. And I'm Judge Thornton, Thornton. I just have to join in if everybody's spelling their last name.
Spelling bee, Your Honor, absolutely.
All right, so what do we got, please?
This is a plaintiff's motion to reschedule the foreclosure sale. Final judgment was entered on June 12th, 2013. There were a few bankruptcies filed along the way. The most recent one, it's case 18-BK-21085, was dismissed, and the plaintiff at this time is seeking to reset that sale.
Okay.
Okay. The 2013 final judgment was in rem. It said that they would not seek a deficiency. Throughout the bankruptcy filed in 2013, November 2013, it was concluded and discharged in August of 2017. Throughout the bankruptcy, the defendants had paid a total amount of $39,400 to the servicer, Aquin, and following the month after the bankruptcy concluded, defendants received a letter offering a trial plan of modification of the loan, and the trial payments in the loan, the trial payments pursuant to the loan modification offer stated that if defendants paid $2,687 for the months of November 1st of 2017, by the second payment by December 1st, 2017, and the third payment by January 1st, 2017, the loan mod would be effective and the loan amount, the amount would be permanently modified. I have a certified mailing receipt dated October 16, 2017, and showing that the defendants mailed the first check. However, they post-dated it. It was returned, and they received a notice from Aquin on October 24th, 2017, stating that returning the funds. And in this notice, which I have
Does that mean they post-dated it? They put the November 1 date on it, and then even though they sent it in mid-October?
They sent it back, yeah.
Okay.
So I have a copy. Okay, so it said it provided alternative methods of making the payment, which included a MoneyGram. It said you can use a MoneyGram. It said the receiver code for Aquin was 2355. Defendants went to Walmart and made the wire transfer on October 30th for the full amount of the first trial payment. I have receipts for all three.
Okay, where are we going with this? All
So
right, keep
basically,
going. So they made the first payment.
They made all three. I have three.
Okay.
And I have receipts for all of them. And they're continuing to make payments afterwards. So, I feel like we filed a motion to vacate, and but right now we would just like an evidentiary hearing to flush all this out, because defendants have paid nearly $40,000, and there's evidence that it's been permanently modified.
So what about? So you're telling me that they made the February 1 of 18 payment, the March 1 of 18 payment? They made every payment since every month.
I don't want to represent that because it was a lot of documents that were brought to me. However, I just wanted to, I see that they've paid nearly $40,000 bankruptcy. They made the 3 trial payments, and that I have other checks showing they're continuing to make payments.
Okay.
Your Honor, in response, defendant, they did file a motion to vacate final judgment, which I don't think is proper at all. The motion itself was filed a few days ago, and it's not verified, doesn't have an affidavit. It's been over 5 years, if not 5 years. Additionally, since final judgment's been entered, additionally, the documents sent to us last night, including the Walmart receipts, that's all fine and good, but no final copy of a signed modification between the two parties. At this time, plaintiff would respect the request to proceed forward with resetting the sale, as this is a 2011 case with a 2013 final judgment.
All right, well, I'm going to do 2 things. I am going to reschedule it. I'm going to give it 120 days. All right, that's number 1. Number 2, I'm going for the sale date. Number 2, I'm going to order either mediation or reconciliation. You all let me know.
All right.
What would you rather have? No, I'm gonna put it in the order now. My question is, with the two of you,
I think a mediation would be very helpful.
I think so too, based on what you're telling me. But
If we can split the cost, Your Honor, mediation.
of course it would be, yes. All right, mediation within 60. No, I take it back. I need it to be sooner. If this is a 120-day sale, there's gonna need to be certain documents that get, sent as far as the final loan modification, if there is gonna be one. Let me hear from both sides in that regard.
Because there's,
How soon can we set?
how soon could we have the mediation?
Yeah.
I think we could have it within 60 days. Regarding the rescheduling of the sale, it was previously canceled twice by plaintiff's motion, 2 or 3 of plaintiff's motion due to loss mitigation or loan modification.
Well,
And I feel like-
that's where I'm headed. I'm wondering whether or not I should reset it or not. What I'm inclined to do is this, because I can set it relatively quickly, all right? Rather than set a date and then cancel it, let me not reset it. I'm gonna order mediation within 45 days. If it doesn't work out, then I'm telling the plaintiff, I want you to put it on the calendar immediately, and I'll reset the sale. Okay, so mediation within 45 days. The motion to reschedule is denied without prejudice. Okay?
All right, thank you, Your Honor.
Thank you very much, Your Honor.
Let's do, what did you sell? You did 9 and 10?
8 and
8 and 10, let's do 10 first.
Take care, Your Honor.
All right.
Good morning, Your Honor.
All right, hold on. So this is number 10.
Correct.
This is the case number 15-10537. This is the motion to reset the sale, correct?
Correct, Your Honor.
Okay.
The defendants are here. She's Maria Diaz. There was a bankruptcy in this case. The bankruptcy got dismissed. There was an order entered January 29th. They're a little confused. They represented themselves in the bankruptcy, and they're a little confused as to they were making payments into the bankruptcy court to the trustee, and they thought the foreclosure was just going away. All we know on our part is that the bankruptcy was dismissed on January 29th. I told her that they would need to speak to Third Federal, which is my client, and speak to the trustee to see what the situation is. But at this time, we're moving forward. Since the bankruptcy was dismissed, we were moving forward to reset the sale. I could do an extended sale date so that they could try to figure this out in the meantime, but.
Okay.
We've been paying on this for the second mortgage to the trustee since January 18,
You all own the
2018.
first mortgage or the second mortgage?
Second mortgage.
The second, Your Honor.
Okay. And what's the story with the first mortgage?
No, that's fine. That's already cleared and closed. We're paying on it perfectly fine. The last one that we did was the second mortgage, which is Chapter 13. But everything was set, and I don't understand why she received this saying it was dismissed. I don't know. So I would have to call and to find out what's going on, because I didn't know. Since I had the court date, I came over here to see what was going on. So I have to call them myself and find out or settle it with them, because we are making payments and we do have proof of that.
Okay. What's the time frame on if they're told to go ahead and submit a package? What's the time frame on the whole situation?
Well, from the time a complete package is received, 30 to 45 days, Your Honor.
All right.
For review.
I'm gonna reset it for 90 days.
Okay.
Sale. All right. That'll give you all plenty of time.
Yeah, of course.
But don't wait.
Oh, no, I'm doing this today. Don't worry about it, yes.
All right.
What's the date, Your Honor?
May 28th.
Okay, thank you, Your Honor. I'll give you a copy now, okay?
You also had number 8.
Number 8, correct. Go ahead and take a seat. I'll give you a copy. Sí. Ahora sí, sí. Number 8, Your Honor.
All right, is anybody here? on the other
Nobody's
side? I
here.
saw the objection, I read it, but there's nobody here on it?
Correct.
Okay, this is case number 15-683. All right, no, there's nobody here, and nobody's checked in, Arthur? On
which
number
case?
8, on number 8?
No, Your Honor.
Okay. All right, I've read it, the objections are overruled / denied. Issue the certificate of
Perfect.
title.
Let me just put it here. Thank you, Your Honor.
Number 4.
All right, number 4. All right, everybody's here?
Yes, there's 2 of the heirs here.
Okay.
One that's represented by counsel as part of the agreed order, and Your Honor said there was people that were calling in.
Thank you for calling Court Call. Please remain on the line, and the court call or court conference operator will be with you shortly.
Hi, may I have your name and the name of your court, please?
Yes, this is Judge Thornton from the 11th Judicial Circuit of Florida.
My name is Sherelle. I will be your operator. Would you like to know who's online?
Yes, ma'am.
One moment. At this time, we currently have Melissa Morrell online.
All right, great. But not Sophia Dean?
No, I'm only showing one person on my reservation.
Okay. All right, would you please join Melissa Muriel, please?
Her line is open.
Okay, great.
No.
All right, we're here on Sovereigns versus Hermance, case number 12-36711. Let me have appearances, please, and I'm going to start on the phone.
Good morning, Your Honor. This is Melissa Muriel. I represent Sovereigns Association,
Okay.
and we are the plaintiffs.
Gotcha. Good morning. All right, and then here in the courtroom?
I'm Laura Tapia. I'm here for the plaintiff with an agreed order.
Okay. All right.
I'm Deborah Murphy. I'm one of the heirs.
Okay.
I'm Julie Hermans, one of the heirs.
Okay.
Thank you.
All right. Now, tell me what you have, what you've heard, and then I'll hear from
Plaintiff
everybody else.
filed an affidavit of additional advances for assessments and other fees that totaled to $2120
Right. I have it.
from the
I'm looking at it.
surplus. So a remainder of $48.79 is in surplus held by the clerk. 3 motions for surplus were filed by the defendant heirs, of which are part of this agreed order. They will split the remainder of these surplus funds. That includes Ms. Hermans, who is here, who is represented by counsel.
Okay.
The rest of this is another Ms. Murphy, is also an heir, but she did not file anything with the court requesting to participate in the surplus.
Within the 60 days?
Yeah.
Can I speak?
Yes.
Okay. All right. The way I read the paper, I thought that the 60 days was for like anyone that we still owed money to, like the condo association, attorney's fees, whatever. That's what I thought the 60 days was for. I didn't realize that I had to file a claim within 60 days.
Okay. Well, let me tell you, legally, I'm stuck. Okay. I got to follow the law.
Right.
However, if you talk to the person immediately to your left, maybe there can be an agreement that gets worked out between everybody else, all the other heirs.
Well, see, that's the problem.
It all gets split.
There were 10
But
heirs.
I know, but I can't get into that now because the only thing that I have in front of me are the people who actually did file.
Right. And see, I've called here, and they told me in my best interest to show up here today. I drove down, both of us drove down last night from Central Florida to be here today.
Well, let's put it this way. After today, it's going to be her money.
Right.
if you're gonna drive back together, I don't know. Who knows what's gonna happen on the trip home, you know? I mean, sometimes things happen.
So there's no changing.
I can't.
The other
Legally,
two
I don't have
that
the
have
ability
filed
to
the
do
claim, we've never even met them. They came into the picture after our parents were
After we
deceased.
presented a contract to sell the condominium, and we had one stepsister
Well,
that
you're-
would not,
Who are you talking? Tell me who you're talking about.
about the
Oh, before it went into foreclosure, we had an opportunity to sell. We had a buyer.
Okay.
And
Oh,
since there were 10 children involved as heirs,
right.
one of them, Mary
Margaret.
Margaret Tobias Kroll, she lives up in Michigan. She would not have any contact with us at all. She wouldn't agree to anything. So therefore, we were unable to sell it, and then we lost it.
I mean,
and the two that made the claim now, we've never met them.
They've never
I
met
mean,
our parents or anything.
I-
They were married to our stepbrothers after our parents were deceased. And now they're deceased, the two stepbrothers. And so these are the,
Well, Mary Margaret Kroll is never filed a claim, so she's not getting it.
Wendy, who's Wendy Smith?
We don't.
we've never met her. I guess it's
She-
our
she-
stepbrother's wife, but he's deceased. We've never met her. She got married him after our stepdad and my mom died.
Is that part of the agreed order?
Yes.
I mean, my stepfather was. We owned that condominium.
Is
for
she in
years.
fact an heir in the probate estate?
I have
She
a copy
was
of the
not.
will. No.
You have a copy of the
I
will?
do,
She
yeah.
was not. Michael, Tobias, Christopher Tobias, those were my stepfather's sons. They were the heirs. And these are wives of them. When my stepfather died, Christopher Tobias was not even married to Wendy. She came long after. So
Was she an official heir to the in the probate estate or not?
No.
no.
I have a
No.
copy of all that.
It was, we have on my mom's side 5, and there were 5 on my stepfather's side. There were 5 and 5. That's why it was deeded, unfortunately, to 10 people. It was Mary Margaret, Christopher, John,
And who's the other person that the
Christy.
agreed order was worked out?
And Julie Hermans.
Okay.
and Christy.
Christy, well, I guess
Together with Christy Tobias and Wendy Smith, which are the widows of the two
stepbrothers that are deceased,
Right.
that are deceased.
that we've never met.
Well, I'm not so concerned about whether you sadly
Right, I
whether you've
understand.
met them or not.
Right.
I mean, but I am concerned about whether or not they are actual
Heirs.
heirs according to distribution from the probate estate.
Right.
Do you know the answer to that?
No, I don't. And
Where's the probate estate?
my suggestion to the court
Is
would
the
be.
probate estate here in Miami?
I don't know. Did you probate in Miami?
Everything was
Yeah.
in Miami. It was done through Charlie Pappy Sr. or Junior, one of them.
No, Junior. All right.
One is, well, the one's
Then-
deceased. The dad is deceased. It
Okay.
was him.
Here's what I'm going to do.
Is it?
I would suggest John
I'm going to
can
give
award the
only.
plaintiff and set an evidentiary for the rest.
I'm going to give only the plaintiff their funds, and I don't remember what's the total amount.
21.
Here, ask
Yeah,
him.
20.
it's a little bit over 2,000. Right.
Ask
okay.
him.
Would you like to see a copy of the will or anything?
No, that's all right. And then what I'm going to ask is, I know Mr. Pappy, okay? I know he had represented one of the
Mary
defendants
Margaret.
in this case.
Right,
Yes,
Kroll.
Mary Margaret Kroll.
His father represented, he's the one that
Right.
did with my stepfather the will because he was my,
So what I want to do is I'm gonna save and not have the clerk's office send. How much is remaining then? There will be remaining-
487908.
All right. Tell Mr. Pappy that there's approximately $4,800 remaining in the clerk's office registry. Okay, so that I want him talking with. This is his pro bono work. Okay, since I know him, I went to law
Problem
school.
is, he doesn't return phone calls.
He doesn't return.
I've called him so many times and never got a return phone call.
I don't know whether
His
he's
dad
in
was
town.
a personal
I know.
friend of my stepfather's.
Okay,
I mean,
so
we
what
know
What
Charlie.
I want is you tell him that, leave a message and tell him that Judge Thornton asked you to call him, okay? And then that I want it put on the calendar for the remainder of the money, the other $4,800, okay? And I'm sorry you all drove in. You're gonna get some for sure. I don't know about, I wanna see who.
I just wanted to be fair to my siblings. That's
No, I
all.
got you. I agree with you.
Because it was Mary Margaret was the whole reason it didn't get sold.
And that's why we lost it.
Because she would not sign the contract. 40-something years we've owned that condominium.
Hey, okay.
Disaster.
Yeah,
Okay.
that's crazy.
All right, let me see, work on the language of the proposal.
Yeah, I'm gonna do a new order because this one has the disbursements to the other defendants.
Right,
So
I mean,
I'll
we
just-
can change that and I can initial it and the changes,
So
but
you're awarding plaintiff's motion and the
Correct.
remaining motions will be set for evidentiary hearing,
that's correct,
correct?
yes.
Laura, can you do number
Or
11?
just say, set for hearing, just say set for hearing.
Set for hearing, the
Set for
statute
hearing.
does require evidentiary.
No,
There's-
I understand that, but the initial hearing is probably gonna be to set the evidentiary hearing and
Okay.
see what the parameters are, or see if everybody can agree.
Okay,
Your
no
Honor.
problem.
Judge, can we do number 11, Laura's on that too? You guys can sit down now.
Your Honor, I'd just like to state that 3 of my step siblings are deceased. And
Okay.
2 of them are the ones that are claiming, right? 3
They're
of them.
quiet.
Chris, yeah.
Chris, John, and Joe.
Chris, John, and Joe.
No, not Joe.
I mean,
Chris,
Chris, John, and
Michael.
Michael. Too
It's tough
many.
keeping track, but I'm sorry, thank you for both, for driving down.
Thank
But
you.
We'll take care of it, we'll get to the
So,
bottom.
do I do anything now, or
Well, no, I
Let
still
her-
want you to call
Charlie
Mr. Pappy's secretary
and say
and
that
tell him that Judge
he's to call
Thornton
you?
said.
He's to call you or call us?
No, he's to call you guys.
Okay.
He's to call you all back and you all describe to him what happened.
Okay.
And he's gonna put it back on the calendar. Okay, but we'll take care of it.
Okay.
All right, I just wanna make sure I'm fair to everybody.
Thank
We
you.
appreciate that,
Okay.
honestly.
All right, thank you, Miss Muriel.
Thank you.
Thank you, Your Honor.
Do we leave now?
Yeah, you can leave, I'll send you a copy of the order. And the other attorney's gonna get a copy. You're welcome.
Thank you, appreciate
Let's
it.
do number 11, Judge.
All right,
Number 11 is a motion for writ of possession.
10.
Title was issued to the plaintiff August 16th, 2018, and the tenant letter was
no, I'm just
sent out
looking for my notes.
September
Oh,
5th, 2018, which
I
has
read
expired.
it. It's great, I'm granting it.
Thank you.
Let's do number 12, please, Monique.
This is number 12.
Good morning, Your Honor.
This is on the writ of possession.
No, Your Honor. Number 12 is on plaintiff's amended motion to direct clerk to issue certificate of title and to place case on active status. The reason why, when the sale occurred, after the sale
Why
occurred,
give me the case number, 17-20227.
that's not mine. Number 12 should be 2012-43321, which is U.S. Bank versus Garcia.
Hold on. Okay, that's number 11 then. Okay.
That's number 11. I apologize, Your Honor.
Sorry.
there. My case was number 11.
I thought I
The
heard
red that you
yes.
just signed.
Number 6. Camilo. Number 6, Judge.
I apologize. Initially, I checked in for number 6.
You're killing
Then, I'm so sorry. Then I corrected that it's number 12, and it is now number 6. I apologize.
All right.
Number 6. Your Honor, everybody was properly noticed. I really don't expect any objection, but hopefully nobody came in here on number 6 before. But the
No, you did not.
no, this is plaintiff's
All right, yeah,
amended.
no, Grant, I want to put it back on active status and issue a
Yes.
certificate of title.
Thank you so much, Your Honor. The order states us to that effect. Granting the motion.
612, what's in a number?
Thank you so much, Your Honor.
It's okay, Judge's money. You can't do no wrong. Number 15, 215, 17,
Okay. Good morning, Your Honor. This-
1-5.
Number 15. Yes. This is plaintiff's motion to strike affirmative defenses. This hearing was properly noticed. Not sure if anyone is in court call or not. But there are 6 affirmative defenses filed by the defendant. We're actually only seeking to strike 4 of them, with 1 being standing, which we filed a reply to, and then 4 being conditions preceding, which we filed a reply to.
No, I'm just looking at my notes. I'm going to grant it as to all affirmative defenses.
As to all? Okay.
Yes.
And I will write out an order to that effect, Your Honor.
Yes.
Thank you very much.
Tim, do your rest.
Oh, okay. Number 18, Your Honor. This is,
On the motion to order show cause.
correct. Aqua Loan Servicing versus Fisher.
Has anybody showed up on that?
Yeah.
Position? No. All right, it's granted.
Thank you very much, Your Honor. Plaintiff would request the first available sale date, and I have the original note and original mortgage for filing as well.
Okay, I'll need that. What do you, let me see. April 15.
April 15th? Okay.
Yes.
I'm going to fill out the final judgment for Your Honor and then bring it up.
Please.
Thank you very much.
I say you all finished them?
That's it. Thank you, sir.
Sir, what's your number?
17.
Okay. Your number? 17. Number?
7. Good morning, Judge. This is number 17 on the docket.
This is on Cazares versus New Century Mortgage?
Yes, Your Honor. The motion was properly noticed. It was coordinated with Ms. Cazares by email. I'm not sure why she's not here. In any event, this is our motion to dismiss the complaint. There's 2 counts of quiet title count.
I've read it. I'm granting it with prejudice.
Thank you, Judge.
Good argument.
Thank you, Judge.
Number 7.
In your papers then.
Good morning, Your Honor.
This is on the motion to intervene.
Yes, Your Honor, there was a hearing on it on December 12th. You ordered the parties to either do conciliation or mediation. We reached out to opposing counsel 12 times. I got 1 phone call back, and then I spoke to his assistant once, and she said he'll call you back. Didn't get anything. I actually have proof that while they claimed that the note had been paid off, the borrowers have kept on making payments timely. So obviously it hasn't been paid off, which we had shown you beforehand, and I have other documentation. We actually, my former client gave them an escrow. They had an additional amount in the escrow.
The original motion, do you have that?
Yes, Your Honor.
Because I can print that out. Let me see.
I just put number 7 on it. That was me today.
Yeah, I'm granting it. You have a proposed order there?
Yeah, I just was gonna, let me fill it out and I can give it to you in a minute if that's
Yes.
okay, Your Honor.
Okay.
Thank you.
Please do that.
Judge, we have, you passed number 2 and 3, which is Michael Kaufman. He's
Yes.
outside speaking to the other side.
Okay.
That's our last case.
Okay.
Judge, it just said he was for something. Oh, okay. Okay, so, Judge, so those people were talking about a lot of money, it's only $4,000. And it's like, how many people still?
Well, there aren't that many left. The issue, so we'll see. Yes, sir.
Very much, Your Honor. This is the order striking the affirmative defenses. So, as well. This is the final judgment I've written in the April 15th date.
Yeah, that's what I was going to double check.
And I have copies along with the cover sheet and the check. And the originals as well, Your Honor.
What's your number? Number 7. Yes, thank you, sir. That's the original.
Thanks.
Number 5, thank you. Number 7.
Is that an official legal word? That the original note is hereby uncanceled?
Is Michael outside, your turn?
Yeah, I thought attorney's not here.
Okay.
They're out, still talking?
I think
Michael is here, the other one is not here.
the other attorney went someplace else, that's the problem. Mike is waiting for him to come back. Sir?
All right, well, I tell you what, as soon as he gets back, I'll be in chambers. Tell everybody to come and let me know, and
I'll wait for you.
I'll take care of it. Okay.
Your Honor, on a completely non-official issue, would you let Dave know that come back to the youth center on Saturdays?
Yeah, oh yeah, I'm,
Just let him know we need a few bodies.
They moved up
They're in
north.
Weston.
Yeah, he lives up in Weston, so he's got, regular basketball game up there on Saturday morning, so.
It's cheating on us. Thank you, Jonathan.
Have a good day, sir.
See you later.
In the front? Easy. There's the equipment, but you gotta get the basic deal. All right, please.